Good evening, everybody.
Good evening.
Good evening.
Okay, good evening. So, shall I start the presentation?
Yes,
Yeah.
yes.
Okay. So, I'll proceed with my second topic, which is so this is my second topic, which I'll be presenting in the form of a PowerPoint presentation as a part of my video making task for the Amikus Qriae. The topic is law relating to regulation of strikes and lockouts according to the Industrial Disputes Act 1947. So I'll share the screen once. Just wait a second. Is it visible? Hello.
No, the
Oh,
screen
it's
isn't
not
visible.
visible.
Okay, one second. Now
Yeah, visible now.
visible now. Okay.
Yeah.
So yeah, as I've mentioned, the topic is, as you can see, law relating to regulation of strikes and lockouts according to the ID Act 1947. So the first slide is about strikes and lockouts, and I'll begin by explaining the terms that are strikes and lockouts. First of all, strike is a collective stoppage of work by workmen undertaken in order to bring pressure upon those who depend on the sale or use of the products of the work. Ludwig Teller, in his book Labor Disputes and Collective Bargaining, opines that the word strike, in its broad significance, has reference to a dispute between an employer and his workers, in the course of which there is a concerted suspension of employment. Because it is an expensive weapon, the strike is generally labor's last resort in connection with industrial controversies. Second one is lockout. Lockout is a weapon in the hands of the employer, similar to that of strike in the armory of workmen, used for compelling persons employed by him to accept his terms or conditions of or effective employment. In lockout, an employer shuts down his place of business as a result of reprisal, or as an instrument of coercion, or as a mode of exerting pressure upon the employees with a view to dictate his own terms to them. So now I'll begin by the explaining the laws that are attached to these terms, strikes and lockouts. And the sections that I'm going to mention in the following slides are about section 22, section 23, section 24, section 25, and section 26. So I'll begin by explaining section 22 first. Section 22 mentions about the prohibition of strikes and lockouts. Section 22 of the Act deals with the prohibition of strikes and lockouts. This section applies to the strikes or lockouts in industries carrying on public utility service. Strike or lockout in this section is not absolutely prohibited, but certain requirements are to be fulfilled by the workmen before resorting to the strike, or by the employers before locking out the place of business. So the conditions laid down in section 22 clause subsection 1 are to be fulfilled in a case of strike in any public utility service, and conditions as laid down in section 22 subsection 2 are to be fulfilled in case of any lockout by the employer carrying on any public utility service. So there are various subsections under this section 22. So I'll begin with the section 22(1). This means that section 22 subsection 1 provides that no person employed in public utility service shall go on strike in breach of contract without giving to the employer notice of strike within 6 weeks before the striking, or within 14 days of giving such notice, or before the expiry of the date of strike specified in any such notice as aforesaid, or during the pendency of any conciliation proceeding before a conciliation officer, and 7 days after the conclusion of such proceedings. It is to be noted that these provisions do not prohibit the workmen from going on strike, but require them to fulfill the conditions before going on strike. Now, moving on to section 22 subsection 2, it lays down that no employer carrying on any public utility service shall lock out any of his workmen without giving them notice of lockout as hereinafter provided within 6 weeks before locking out, or within 14 days of giving such notice, or before the expiry of the date of lockout specified in any such notice as aforesaid, or during the pendency of any conciliation proceeding before a conciliation officer, and 7 days after the conclusion of such proceedings. As we have seen, most of the provisions or the conditions here are same as related to the strikes and lockouts are almost same. Just the definitions are different. So now moving on to the section 22 subsection 3, it provides that the notice of strike or lockout as provided by subsections 1 and 2 may in certain cases be dispensed with. Now it says that no notice of strike shall be necessary where there is already in existence of a lockout in public utility service concerned. No notice of lockout shall be necessary where there is already in existence of a strike in public utility service concerned. Section, now moving on to the next slide, which mentions about the section 22 subsection 4. It says that the notice of the strike shall be given by such number of persons to such person or persons in such manner as may be prescribed. Section 22 subsection 5 provides that the notice of lockout shall be given in such manner as may be prescribed. Section 22 subsection 6, which is the last one, deals with the intimation of notices given under subsections 1 or 2 to be specified to specified authorities. If on any day an employer receives from any person employed by him any such notice as is referred to in subsection 1, he shall within 5 days report to the appropriate government or to such authority as that government may prescribe the number of such notices received on that day. Similarly, if an employer gives any notice as is referred to in subsection 2 to any person employed by him, he shall report this fact within 5 days to the appropriate government or to such authority as the government may prescribe. So, as you may wonder what appropriate government here means, appropriate government, for example, mentions about the state government or the central government. For example, for some issues, the matters may be mentioned to the state government, and for some issues, the matters may be, for example, maybe given to the central government, or it depends from issues to issues. And the appropriate government, for example, the government that is concerned in a particular case is known as the appropriate government. Now, moving on to the next topic, we have the prohibition of strikes and the notices of strikes. Prohibition of strike is another element which we all should be acquainted with. Where a strike has commenced during the pendency of conciliation proceedings and the workmen pleaded that the strike was provoked by the employer, it was held that the fact that the strike or lockout was provoked by the opposite party will not absolve the person going on strike or declaring lockout of the duty of complying with requirements of sections 23, 22 and 23 of the Act. The words no person appearing previously in the subsection refers to workmen because no other person than a workman is likely to go on a strike in an industry, and that is obvious. It must further be proved that the workmen were employed in an industry which was a public utility service within the meaning of section 2 clause N. So now what about the notices of strikes and what are the responsibilities on the part of employees regarding this? In mineral miners union versus Qriae Iron Ore Company Limited, it was held that the provisions of section 22 are mandatory and the date on which the workmen proposed to go on strike should be specified in the notice. If meanwhile the date of strike specified in the notice of strike expires, workmen have to give a fresh notice and all other statutory consequences flowing out of the said notice would follow. It is not correct that the provisions of sections 20 subsection 1 and 12 subsection 1 of the Act are not applicable to the second notice. Whenever a notice under section 22 is issued, even though such a notice is necessitated by the failure of conciliation proceedings, provisions such as sections 20 clause 1 and 12 subsection 1 read with section 22 in its entirety will be attracted. It was further held that deduction of the wages for days of illegal strike would be justified. In ANZ Greenlace Bank versus SN Khatri and others, the Bombay High Court, following the decision in Syndicate Bank versus K. Umesh Nayak, held that once the strike is held to be illegal, the question of justifiability does not arise and the employees in public utility services are not entitled to seek wages for the strike period unless they prove that the strike was legal and justified. So it means that whenever an illegal strike is going on and workers are not able to work or they are not in their working period, they cannot ask for wages until and unless they can prove that the strike was legal, and that the strike, whoever accused them of going on a strike was not justified. They cannot ask for wages. So now I'm going to talk about the prohibition of lockout. The prohibition contained in section 22 subsection 2 against the lockout by the employer is similar to that against the strike by workmen. In case of a lockout, the prosecution has to establish that the lockout is in a public utility service. Like subsection 1, it need not be shown that the lockout is in breach of contract, for this expression is missing in subsection 2. So far as lockout during the pendency of a conciliation proceeding is concerned, provisions relating to strike in this connection shall apply here also. A conciliation proceeding relating to a matter concerning all employees may bar a strike or lockout as the case may be, but if the proceeding is confined to a specific demand concerning a class of employees, the other workmen who are not interested in the demand may not be bound by it. So you all must also wonder that what a conciliation proceeding mentioned in the slides are. So whenever there is a argument or quarrel or a fight between the employers or the employees, that is the workers and whoever uh, employs the people for work, when there is a quarrel between them, there are always organizations in an industry who mediates or comes as in the form of a middleman in order to reduce the fight or to come with a solution. Those organizations are known as conciliation organizations, or that process is known as conciliation proceeding. So now moving on to section 23, it consists of general prohibition of strikes and lockouts. The prohibition against strikes and lockout contained in section 23 is general in nature. It applies to both the public utility as well as non-public utility establishments. A strike in breach of contract by workmen and lockout by the employer is prohibited in the following cases: during the pendency of conciliation proceedings before a board and 7 days after the conclusion of such proceedings; during the pendency of proceedings before a labor court, tribunal, or national tribunal, and 2 months before after the conclusion of such proceedings; during the pendency of arbitration proceedings before an arbitrator, and 2 months after the conclusion of such proceedings, where a notification has been issued under subsection 3A of section 10A, or during any period in which a settlement or award is in operation in respect of the matters covered by such settlement or award. The object of these provisions seems to ensure a peaceful atmosphere to enable a conciliation or adjudication or arbitration proceedings to go on smoothly. This section, because of its general nature of prohibition, covers all strikes and lockouts irrespective of the subject matters of disputes pending before the authorities. The next section that I'm going to explain about is the section 24. This section mentions about the illegal strikes and lockouts. So now although we have talked about the strikes and lockouts, the definitions and their provisions, we now have to see how they are illegal and how they are not considered to be valid in some cases. So according to section 24 subsection 1, a strike or lockout shall be illegal if it is commenced or declared in contravention of section 22 in a public utility service, commenced in contravention of section 23 in any industrial establishment including both public utility and non-public utility service, and the third one is continued in contravention of an order made by the appropriate government under section 10 subsection 3 or subsection 4A of section 10A of the Act. The subsection 2 of this section, that is section 24, provides that where a strike or lockout in pursuance of an industrial dispute has already commenced and is in existence of the time of reference of the dispute to a board, an arbitrator, a labor court, tribunal, or national tribunal, the continuance of such strike or lockout shall not be deemed to be illegal provided that such strike or lockout was not at its commencement in contravention of the provisions of this Act, or the continuance thereof was not prohibited under section 10 subsection 3 or subsection 4A of section 10A. According to the section 24 subsection 3, a lockout declared in consequence of an illegal strike or strike declared in consequence of an illegal lockout shall not be deemed to be illegal. Now moving on to section 26, it talks about the punishments that the workers will receive when they go for illegal strikes. The punishment of illegal strikes is yet another topic which is very important. The workers have a right, if not a fundamental right, to go on a strike. If a strike is illegal, the party guilty of the illegality is liable to punishment under section 26 of the act, as you can see in the slide. Even in case of illegal strikes, a distinction has been attempted to be made between illegal but justified strike and illegal and unjustified strike. Now, how can a strike which is illegal be at the same time justified? It is said that the strike may be technically illegal because it is in contravention of the provision of this act, but because the causes that led to a strike are often mixed question of legal and illegal demands. A strike may not be unjustified, but the conduct of workmen may be objectionable or their behavior may be violent. On the other hand, a strike may be illegal, but it might have been taken recourse to for good reasons and carried on in an orderly and peaceful manner. It is for these reasons that even illegal strikes are classified as justified and unjustified by those who administer at industrial law. Now I'm going to speak about the punishments that are given or the penalties that are given for illegal strikes and lockouts. Any workman who commences, continues, or otherwise acts in furtherance of a strike which is illegal under this act shall be punishable with imprisonment for a term which may extend to 1 month or with fine which may extend to 50 rupees or with both. The second one is any employer who commences, continues, or otherwise acts in furtherance of a lockout which is illegal under this act shall be punishable with imprisonment for a term which may extend to 1 month or with fine which may extend to 1000 rupees or with both. The last section that I'm going to talk about is the section 25, which mentions about the prohibition of financial aid to illegal strikes and lockouts. Your financial aid means that no one can donate or support any illegal strike and lockouts with the help of money or revenue. So this section of the act prohibits financial aid to illegal strikes and lockouts. It says that no person shall knowingly spend or apply any money in direct furtherance or support of an illegal strike or lockout. The section has the following ingredients: spending or applying money, money spent or applied in direct furtherance or support of an illegal strike or lockout. The strike or lockout must actually be illegal. Knowledge on the part of the person expending or applying money that the strike or lockout is illegal. So the last point means that the person who is giving money should have the knowledge that the strike for which he was donating or supporting the strike or the lockout with the help of revenue was illegal. If we did not have any prior knowledge that the strike was illegal and it was not valid, he may not be held liable for that. So it is sufficiently clear that person spending or applying money must know that the strike or lockout is illegal. Thus, mens rea is a necessary element of an offense under this section. The provisions of this section are attracted only if the strike or lockout is illegal and not otherwise. So this is the end of the presentation, and these were all about strikes and lockouts and the laws relating to it according to the ID Act of 1947. So 1 second. Was it clear? Hello?
Yeah, we can hear you.
Hello?
Yeah, we can
Yeah?
hear you.
Yes.
You're audible.
Yes. Okay, 1 second. Okay then, thank you so much. Hope you understood and got a gist about what strikes and lockouts were all about and the laws relating to it. Thank you for being so patient, and okay, have a good evening. Thank you.
Thank